once again, and you're welcome to School's Law. So today we are going to be talking about assault under the law of tort, right? So you remember in our very first video at School's Law, we spoke on battery, and today we are going to talk about the twin brother of battery, okay, which is assault, right? But just before we zoom into our topic for the day, if you have not subscribed, kindly subscribe and turn on the notifications button so you get notifications when we post new videos. Like our previous videos, share, comment, and as I always say, your comments are very important because they let us know what you want and what to actually give you, what information to give you. But then again, as we have done in previous videos, I would just like to issue this disclaimer that School's Law is mainly for educative purposes. We are not lawyers and we do not profess to be lawyers. Whatever it is that we share here, it's mainly for educative purposes. It's just for no sake, and it's also for law students, Ghanaian law students, to be able to get some form of material like some study partner or some study guide or something. It is not legal advice and you cannot rely on same as legal advice. School's Law will not be responsible for you taking the information we give in our video as legal advice, right? And so, straight into our very first our topic for today, right? So, as I said, we are going to be talking about assault, and assault is simply incomplete battery, okay? So, when someone hits you, okay, when it is direct, it is intentional, and all the things we spoke about in our video on battery, it is battery, right? So when all the elements are met and the person actually touches you, then we say it is battery. But when all these elements are present, only that there is no physical contact, the person did not touch you, okay, but then the person made you fear or acted in such a manner that made you fear for imminent battery, okay? So the person scared you, the person was about to hit you, which made you scared, but the person did not actually hit you. That is what we call assault. So we say assault is incomplete battery. The difference between assault and battery is that for battery, the person actually hits you, okay? But then for assault, the person, by their actions, okay, makes you fear for imminent battery. The person makes you afraid that they are going to hit you, but then they don't actually hit you, okay? So we look at the case of Ridley Cook. Now in that case, the plaintiff went onto the land of the defendant, right? And the defendant asked him to leave, okay? He refused to leave, and the defendant gathered his workers, and they got these workers together with the defendant, gathered around the plaintiff and started rolling up their sleeves. And then they threatened to break his neck if he did not leave the premises. Fearing for his life, the plaintiff left, okay? Now, he later sued for assault, and his action was successful. In that case, it was held that if anything in law, okay, short of actual striking, will amount to assault, then it was clear that the defendant was guilty of assault. There was an intention to harm coupled with an immediate ability to carry it into execution, okay? In this particular case, these people had actually surrounded the plaintiff. They had rolled up their sleeves, signifying an intention that they were going to batter him or they were going to hit him actually if he didn't leave. So you could see that there was that intention, and based on that intention, he was he became afraid, and it was reasonable. Of course, if someone says they are going to break your neck and they have everything to carry it into execution, you'll be afraid. So it was reasonable for him to have feared for his life and then left. That is what assault is. So assault, as I said, the difference between assault and battery is that battery is actual touching, there's physical contact. But then when the same elements are satisfied, only that the person did not touch you, then we say there is assault. However, there is another case called Thomas versus National Union of Mine Workers, okay? Now in that case, there was a riot. Let's say some mine workers decided to picket. They were on strike. They decided they were not going to work, okay? Now, a portion of them said they were going to work, right? So even when the workers had agreed and that they were not going to work on this particular day and that they were going to demonstrate, these group of workers went on ahead to work, okay? So it meant that they had to sit on the company bus or whatever, and then go through the rioting, the rest of the workers that were rioting. So they were in the bus, and then they had to go through them and then get to the workplace or get to the mine. Now, while they were sitting in the car, while the car drove through the picketing workers, those men that were picketing cursed at them, those that were in the car that had decided to go to work. So you can only imagine, like, all drivers are on strike, and then a certain group of drivers decide to work. So they were insulting them, using all manner of words against them, threats and all of that. Now, one of these workers that was in the bus that had decided to go to work came to sue for assault, saying that the things that the people were saying amounted to assault. But then it was held that yes, it amounted to assault, all right, but then you cannot say that you were afraid. There is no reasonable apprehension of, like, there's no reasonable fear. The fear, even if you feel fear in this instance, it's not reasonable. Why? Because you were in a bus, number one. Number two, there was a police over there, which actually meant that the people could not cross the police and then come to you. All right. So in proving assault, it is important that you prove that the fear was reasonable. So, for example, if a 2-year-old has something like it's holding a fork or a knife, right, and says it's going to stab you, is it reasonable to fear? You that, like, let's say you are 36 or 37, when you say you are afraid, is that reasonable? Do you understand? So the fear has to be reasonable. However, if it's someone, let's say your own koiko, who is holding a weapon, you can say that, oh yeah, that fear is reasonable. So it is important under assault that even though we are just looking at whether or not the person's action led you to fear and whether or not there was the actual presence of that fear, it is important for you to show that that fear was reasonable.